All right, good morning, Mr. Chavez.
Morning.
Mr. Chavez, you're charged with reckless driving. You're facing up to 30 days and or a $500.
Right from the start, we're thrown into the world of street takeovers. These aren't just car shows, they're chaotic, illegal events where drivers risk lives for social media clout. The judge's tone is calm but serious, because in Texas, reckless driving isn't a slap on the wrist. It's a criminal charge that can cost you both your freedom and your car.
Fine, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The Street Takeover Task Force was investigating a takeover in a parking lot in Harris County, Texas, when the officers observed the defendant doing donuts in the vehicle, coming within 10 to 15 feet of other vehicles that made up the pit. The officers saw the defendant do approximately 3 to 4 donuts, and undercover officers maintained visual until uniform officers made a traffic stop. The officers observed the defendant operating the vehicle in the driver's seat.
Mr. Chavez, I'm going to find that there's probable cause to go forward with the case. Do you have a Texas driver's license?
Yes, sir.
Do you have liability insurance in your name?
Not in my name.
Then you're not allowed to drive. I'm going to have you sign an affidavit with me today promising me you're not going to drive. Let me make something else perfectly and abundantly clear to you, that the Texas legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from individuals who partake in this type of action. In fact, we had one here yesterday where a car was seized, a very, very expensive car, on a second. Do you understand?
Yes, sir.
If I find that you endanger my public, then likewise, you will go to jail. I'm going to revoke your bond if you endanger my public. I'm going to do everything in my power to protect it. Do you understand?
Yes, sir.
Before you start driving, you must come back and get approval from us. Do you understand? Don't just start driving, because I don't want to take your word that you have a car insurance. Owen can get with you, come back. He knows how to handle this. Do you understand?
Yes, sir. But the truck has insurance.
I don't you have a lawyer. I don't want you to say anything now.
Okay.
Just get with your lawyer. He can advise you how to go forward. But I'm telling you now, I'm ordering you not to drive. You don't have car insurance.
Yes, sir.
Do you understand, Mr. Chavez?
Yes, sir.
Okay, I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria. We will have you sign a reset. It is your responsibility to stay in touch with Owen. If Owen tells me that he can't get a hold of you because you're playing games, it's not going to go well for you here. Do you understand?
Yes, sir.
All right, come on. Thanks, man. Hey, can you file? So we need him to also sign bond conditions. Owen, I also need him to sign bond conditions, no reckless driving, donuts, racing. So we'll have him take a seat in the jury box. Once he signs it, then
Yes, Judge.
please. Felicia,
Yes, Judge.
when did we first test Mr. Smith?
So for Mr. Smith, I see an order prior to when I was here on October 7th to have Mr. Smith go to a drug test that day. He never reported, so that's why the BVR was filed. And so then we had a test on the 9th, and those were now confirmed by the lab positive use of THC. I believe.
So that was October 9th.
No, October 7th, we ordered them to test, they did not.
Okay.
We caught that a little late, by the BVR, and then we adjusted a little bit last week, I believe, or the beginning of.
How is it that we ordered him to test in October and he's now in December testing? How on earth? It's unacceptable.
It was a court-ordered drug test, and I don't think you wanted them to come back after testing.
But if they don't test, then they're required to come back, and we either make them test again or do so, or there's other ramification, but we don't. How on earth can we go a month and a half and then nothing happens?
Yes, Judge, I understand, but we did, per your orders, we tested them again this week, and those did come back for THC.
Who was here working that day?
I can look into it, but it's really no way of knowing for sure because there was no assigned officer here at the time.
Someone had to have signed an order to go test.
I think so, right?
There's always a way. There's always a paper trail.
Yes, Judge. Sorry, this was from the court. Since they never made the appointment, and it was one of our officers' noses.
What do we do with this, Mr. Brooker? How do we hold Mr. Smith accountable?
Judge, I know what I've done since Monday. Mr. Smith and I have talked very frequently this week. I admonished him thoroughly about the THC usage. He explained to me what happened with that, and he understands the seriousness of it. He understands what's at risk. It's correct what you said, that he doesn't have any support out there, financial or otherwise. I'm actually happy that he was able to make it here on time today, because I was concerned about that. So that was twice this week. He wants to be compliant. He wants to do what's best. He wants to dispose of the case.
I don't believe that.
I know, Judge.
I don't believe that. He's telling me that you want to be compliant. I don't think so. You repeatedly do whatever you want to do without regard to court orders, and it does not work like that. You repeatedly fail to appear here. You blow off the test, and now you're testing positive. What am I supposed to do?
This is where courtroom reality hits hard. Not every defendant is a hardened criminal. Some are just trying to survive, sleeping in parks with no transportation or support. But here's the dilemma. The law doesn't bend for personal hardship. Should courts show more compassion, or would that risk undermining accountability? What do you think?
Dude, just let you go?
I didn't repeat. I missed one day, and that was the day I was supposed to come, and I didn't have no way up here. I didn't even.
You can take the bus.
I'm in Humble. The bus did not come out of Humble. I'm literally sleeping at the park right now, like, okay, and I'm still, okay, listen.
And Judge, even with those challenges, Tristan has been in school. Even on the Zoom appearance from last week, I believe he was Zooming in from school that day, the day that he couldn't make it, and got down here on that Monday.
I don't know what to believe with him. I really don't. Unless you provide me proof with something, I'm not going to believe a word that comes out of your mouth. I don't believe, because the problem is that you tell me that you're going to, you tell me you're going to do things, and then when it's time to, you don't. So how am I supposed to handle this? What am I supposed to do?
Judge, he came in on Monday. You ordered him to take the test. He went right over.
I literally walked here. I didn't have nowhere. I walked here.
He went over.
That was a whole 4 hour. I walked here from school. I walked here all the way from Chattanooga.
I'm not asking much. I don't want you to use. Do you understand?
Judge, if I may add, I have communicated with his grandmother. I believe it was on December 5th that I called
Oh,
her.
you spoke with Grandma.
I did.
Have you let Mr. Brooker know first?
Yes, Judge, I recorded. I took details of the conversation and shared it promptly with Mr. Brooker.
How do we go forward?
So it appears as though, based on my conversation with Miss Karen, that the defendant has gone to the house, the residence since then with his friends. He refused to leave even upon her request. There is a MOAP in place, Judge, where he was supposed to have no contact with the residents, and per his bond conditions, I don't believe he was supposed to have contact with her either. And he has gone to the residence.
And now we have even more. I mean,
And she did file a police report, I believe, Judge. She told me she called the police and they filed a report, and she has an offense number.
Mr. Brooker, do you guys want to talk about this? And then
We can, Judge. We can.
does she want him to come back or no?
Now, my understanding, and I also heard from one of the family members, I believe Tristan's sister, they don't want him to come back. And mentioned something about whatever was the underlying dispute about some property or whatever. I didn't respond to it at all. It just didn't seem like the right thing to do. But as Tristan has indicated, everything he said to me is that he's been living outside, doesn't have anywhere to go, which is my original concern with him. Took him downstairs to try to get him some kind of services. It's just not really a workable situation, but he's communicated with me. We've talked this week. This is his second time here. He took the test, Judge. He was forthright with me. He understands what can happen. I told him,
Saba,
no one's gonna bond you out.
What do you want me to do?
Judge, just that he continue having no contact with any of the complainants. They are fearful of the defendant. They do want him to get help. I've also spoken to his mother, and she wants him to receive mental health treatment. He does have
Do you need a place
propensities
to
towards
stay?
violence.
I have like some nights
No, you were telling me earlier that you're living on the street.
I am.
Do you have a place to stay? Okay.
They told me.
If you want, we have places for you to go. I have services for you. I have Shatoria here. We can find you a place to stay if you need it, because the street, it's not a good place to live. The streets will ravage you in ways that you never know. You'll do things just to survive. It's not a good place to be. So if you need a place, we can find you a place. But that's still no excuse to violate conditions of bond. We've ordered you not to go back to this house, right? I get that you may have, issues, where to live, where to stay, who to be with, how to get there. But if they don't want you there, then you can't go. And I mean, they've already called the cops.
I spoke to his family, Judge. They were under the impression that the defendant was living with a friend in their house, so I don't know.
And that's my understanding too, and Tristan did tell me that he intended to go and stay with a friend. But that was 2 months ago, Judge. He's not paying any rent or anything. His situation has changed since then.
Look, I'm trying really hard not to put you into custody, but at some point, your actions become your own and it's on you. I'm not going to keep playing this game. I'm not, I expect you, like everybody else, to live to the conditions. When we tell you not to go back, it's mom or grandma.
I spoke to both, Judge. Grandma wants no contact.
If I hear it happens again, get ready. You're not allowed to use. And I'm telling you now, I'm going to test you for someone dropped the ball here. And I'm going to give you the benefit of the doubt, but I'm telling you, you're going to get tested again. And if it tests positive again, there's no excuse. Now, we have resources to help you. If you want help, all you have to do is ask. We've given you a list of places that you can call, that you can go stay. They will take you in. If you need any other resources, we're happy to help you as well. But at some point, there's just no more excuse. Understand? All right.
Good, Judge.
Hey, that's it. I mean, really, just no more tolerance. I mean, I don't know, this is what, 3, 4, how many times is this?
It's our second time back since the first time, but I do understand. I agree. Yes, sir. Yes, sir.
All right.
Thank you, Judge.
All right, Saba. So I guess let mom and grandma know, hey, we've tightened the leash. There's no more excuses. Any more issues, let us know. And
Yes, Judge. And to be fair, it was the mother did tell me that she has not seen him. It was the grandmother. And
okay, well, that's good news. All right.
Judge and I.
Okay. Who do we have here?
Mr. McCray, Your Honor.
All right. Good morning, Mr. McCray.
How you doing?
Mr. McCray, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On April 3rd, 2024, the officer was dispatched to an apartment in Harris County, Texas, in response to an assault call. The complainant is the defendant's daughter. The complainant is the defendant's daughter's boyfriend, and the complainant was staying with her daughter, and when she got on the phone call from her boyfriend. The defendant got upset and said he was tired of this bitch's voice, referring to the complainant. The defendant got in the complainant's face and punched her in the lip, causing pain and for her tooth to fall out. The complainant was treated by EMS.
Mr. McCray, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. Do you understand? In fact, I'm going to send you right now for a drug test. I want to know what, if anything, is in your system. I'm also ordering you not to be in possession of weapons and not to have contact with the complaining witness in this case. Do you understand?
But they want to write an affidavit. Can they do that?
I don't answer questions, Mr. McCray. I'm telling you what the expectation of is while you are in this court. You can either abide by the expectation or the other thing is going to happen. Do you understand? Are you high right now?
No.
Be careful. I'm sending you for a drug test. If you fail to go take the drug test, if you fail to come back, you know what's going to happen. Just take a seat for me and then we'll get you. I'm sending you for a drug and alcohol test right now. Do you understand? Take a seat for me, sir. Top of page 11. Sorry, I want to know how come up, Miss Imam.
You just met, so we
Okay.
haven't had a chance to.
I'll give you a little bit of time, but
My understanding is procedurally what has happened is she was on a pretrial diversion.
correct.
Her previous lawyer has passed away.
Mhm.
The state has rescinded or terminated the pretrial diversion that she was on. I've had a chance to kind of go through a little bit of in the way of discovery. She wants to move forward and try to figure out what we're doing with the case, needs me to do that. By way of background, she works as a pharmacy technician at Walgreens, is a student in college. Quite a bit of mitigating stuff. I need to really have some time to dissect it all.
Is she using while she's on bond? Was that the issue?
Let me see, Judge. I'm not sure why Nathan.
Shatoria, tell me about Miss Imam, huh?
It looks like she had continuous violations on her device after being placed on a zero tolerance. She had a pattern of failing to report to visits. She failed to complete SOP. She failed to maintain the alcohol monitoring device. I don't see any. The violations on the device were skip tests.
And Judge, I think there was some times where there were some missed tests. I don't know that.
So I'll give you time,
Yes, Judge.
okay? I'm putting a scram on your ankle now, so I know that you're not consuming alcohol. And if I find that you consume alcohol, or if I find that you're consuming illegal drugs, it's really, really not going to go well for you.
Yes, sir.
Do you understand?
Yes, sir.
Yes.
Does she have a Texas driver license?
Well, let me talk to me.
Just,
You run it, Judge.
Mhm.
Yes,
Looks
she
like it
does.
hasn't been run. Okay. You're running it? Okay.
so let's do this. I'd like her to get a scram today.
Yes.
I'm also going to send her for a drug test because I want to know what, if anything, is in her system. We'll sit you off 2 weeks for you
Okay.
guys to decide what you guys want to do. Okay? Get what you need. Your case is 530 days old. It's time to decide what we're going to do. It looks like they've already kicked you out of the program. I don't know if they're going to relent and let you back in. I don't know. But I'm going to tell you now, let's just cross that bridge when we get there. But
What I would like is if in maybe 60 days or something like that, if things are going well on the scram device, maybe come back in and revisit and get a.
I don't, well, no. I don't know if I'm going to keep the case open 60 days. It's 525
Fair enough.
days. You know, I mean, I'll give you some time,
I just
but
need to make sure all the
Judge, we
discoveries.
do have an offer in on this case as well.
what is
We put
it?
in an offer, a time search.
Okay, so there's an offer. So when we come back, I'll give you 2 to 3 weeks, but when we come back, you need to either accept the plea bargain from the state or I'm going to set your case for trial. If I find that you're using or doing anything to violate the law while you're on bond, now I'm going to put you in jail. Do you understand?
Yes.
That's it. You're not allowed to drive unless you have liability insurance in your name. If you do not have car insurance, do not drive. Do you understand? Okay. So we'll give you 3 weeks,
Yes.
Mr. Garris. But at that time, when you come back,
Set it up. I will
either accept, or if you're going to provide mitigating evidence to the state
try to get back in the program.
before that day, so we know,
I will do that in advance.
please.
Yes.
Okay, Ms. Simon. All
you,
right,
Judge.
so I'm going to put the devices on her today. She gets a test today and all fees waived.
Thank you.
Judge, my apologies, I misunderstood. Could you please go over those conditions again for me?
I want to send her for a drug test now,
Yes, Judge.
and I'd like to put a scram on her ankle now today as well.
Yes, Judge.
Okay? We'll set the case. I'm sorry?
you want Brandon UAs as well?
Well, no, I just want to know if she's clean now or not. And then in 3 weeks, this case is
Yes,
one way or the other.
Yes.
And then, okay,
Thank you, Judge.
all right, guys. Working. Good morning, Mr. Anderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling west on Jester Boulevard. The officer observed the defendant constantly veering out of the lane and going into the second lane. The officer observed the defendant to be the driver and sole occupant of the vehicle, and while speaking to the defendant, the officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant was struggling while exiting the car and was swaying back and forth while speaking to the officer. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused and a blood search warrant was drawn and executed.
Your Honor, may I make argument, Judge?
Sure.
Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Hardin v. State. And in that case, it overturned even Lemming. And they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Yeah,
You have to have provide.
a danger to another vehicle. There's other vehicles around. And this is on TC Jester Boulevard, a very sparse road at night. And this
So
is,
what were the indicative facts?
I'm opening the offense.
Yes, Your Honor, we're looking at the offense report.
I mean, obviously, we don't have any body cam, dash cam, so I'm not,
Right, but this is just a mere probable cause. I need enough of a statement from the officer in the DIMS saying how he justified pulling the car over in light of failure to maintain a single lane. The weaving statute. I mean, do you need a bit of time? If you want to reconvene in like maybe 30
Yes,
minutes,
Judge.
it's fine.
My offense report's not loading for some reason, so.
If we may have a little bit more time.
Mr. Saman, do you have somewhere else to go?
I have Fort Bend to go to. Can I go to Fort
Well,
Bend?
That's going to take hours. If you want to, yes, because you can always zoom in. I have Zoom for
No,
you.
I'll wait. I'll
So
wait.
perhaps maybe, 15 minutes, give them time to look at the OR.
Yes,
All right,
Your
just take a seat for me, Mr. Anderson. We'll come back. For now, we'll have you sign a reset.
Oh, no.
Okay. Hi, counsel.
I've got Moises Serious.
What's the last name?
Moises.
What was the last? SI? Okay.
Soon you know the one I'm talking about.
Say it again.
Somebody walking, black man walking.
Oh. Good morning, Mr. Sirius. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's vehicle at 1:05 a.m. after observing it drive at a westbound on Washington Avenue, following a vehicle in front of him too closely and for having an expired registration. The defendant was the sole occupant of the vehicle and driver, and upon contact with the defendant, the officer observed a moderate odor of an alcoholic beverage, glossy eyes, and low and mumbling speech. The defendant admitted to drinking, and standard field sobriety tests were conducted. HGN was 6 out of 6, walk and turn 3 out of 8, and one leg stand was 1 out of 4. The DIC was read, but the defendant refused, and a blood warrant was signed and executed.
Okay. Mr. Sirius, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, sir?
I do, yes.
Okay. Do you have valid liability insurance in your name?
No, it's not my vehicle.
Okay. If you don't have car insurance, then you're not allowed to drive. I'm making that a condition of your bond. If you want to drive to follow the Texas law, you must have a Texas driver license or a driver's license from another state, and you must have liability insurance in your name.
Yes,
If you don't have both, then no driving. I am ordering you also as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, likewise, your bond will be revoked. You'll go to jail. Do you understand?
Your Honor.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it's your responsibility to stay in touch with Mr. Stone, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you, you're playing games, I'm going to issue a warrant for your arrest.
Your Honor.
I'll have you go to Victoria, sign a reset. We'll have you get with your bond conditions with Felicia, and then you guys are free to go. All right, guys, thanks. It's fine.
Right this way. Next judge is page 2. Chavez, come on up.
Okay. Did you have a?
Good arrangements, Mr. Chavez.
Okay.
You're good.
Good morning, Owen.
Every other weekend, we go to, there's a small restaurant called Prima Pasta. They have a singer who wears a different blazer every time he comes in. How many
Does this look like
it? How many blazers do you, I guess?
Quite a bit. Good morning, Ms. Chestnut. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 5th, 2024, the officer responded to a flock hit for a stolen license plate, and upon locating the motor vehicle, the officer conducted a traffic stop. Upon contact with the defendant, the driver of the vehicle, the officer detected an odor of an alcoholic beverage, slurred speech, and red glassy eyes. The officer confirmed the VIN was a match with the stolen vehicle hit on MDT, and the defendant admitted to drinking 2 drinks, one of which was a large margarita. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 0 out of 4. And the reason for one leg stand being so low is because the defendant walked instead of doing the one leg stand. The DIC was read but refused. Blood search warrant was drawn and executed.
All I see is just the DWI. That's it.
Yes, Your Honor, there was no charges filed, and I don't know the reason for that. We can look more into that, but
It's not, okay, so any prior DWIs?
no, Your Honor.
Did you run or NCIC?
Yes, Your Honor.
Ms. Chestnut, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? ma'am?
Yes, sir.
Have you run a license?
It's eligible, Your Honor.
I'm ordering you now as a condition of your bond not to drive any vehicle unless you have liability insurance as well. It's part of your bond conditions. I am also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If we find that you're consuming alcohol or any kind of illegal drugs, I'm going to revoke your bond and put you in jail. No more PR bonds. Do you understand? Okay. What do you do for a living, Ms. Chestnut?
Social Security.
Okay. Did you want to apply for an appointed lawyer, ma'am?
Yes, sir.
Okay. Do you mind? You know what? Let me see if I have one on file. Hold on. I need you to fill out an application for me. I'll take a look at it to see whether you qualify or not. If you do, then we'll appoint your lawyer. So for now, I'm going to have you go to Victoria, sign a reset. He's going to give you the application, and then we'll have you take your seat in the jury box, ma'am. Okay? Please.
Greta Khalil, page 3.
Good morning, Mr. Craddock. Mr. Craddock, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Judge. One moment. It's loading right now. Okay. An officer was dispatched to a target in response to a theft. The officer made contact with the complainant, the loss prevention officer, who stated he observed the defendant come into the store and make a small purchase, leave, and then return and conceal merchandise in the shopping bags. The defendant then took the concealed merchandise and walked past all points of sale without paying. The total taken was $750.05.
And was he with anyone?
No, Your Honor.
All right, Mr. Craddock, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living?
I am currently waiting for a call to back so I can working.
Say that again.
I'm waiting for our college to get back to me, but I'm currently working at Taco Bell.
So you graduated from high school? Yes. Okay. Did you want to apply for an appointed lawyer, sir?
Would it be okay if I ask my mom that?
Is your mom here? Sure. Of course. Mom, come on up. Thank you so much for coming. Did you hear what happened? Okay. I'm asking him if he wanted to apply for an appointed lawyer. I don't want to talk about the case. I only would like to know, do you want a court-appointed lawyer?
This is his first.
That moment is more than just a lecture. It's a wake-up call. Judges see hundreds of cases like this every week. Young people making one mistake that can brand them for life. When he says life is hard enough for a young black man, he's not speaking as a judge, but as a human being. Moments like this remind us that justice isn't only about punishment. It's about giving second chances.
Let's not talk about the case. I only want to know whether you guys would like a lawyer or not. Let me put it to you this way. You need a lawyer.
I was about to say yes.
So you can either go hire a lawyer right. Mr. Craddock, theft cases are probably one of the worst possible cases that you can pick up in this life. Once you are branded a thief, it's going to be nearly impossible to get a job. I have people that come back to me and say, hey man, I can't get this apartment because I got this theft conviction. Please. It's truly one of the worst. You're just now starting in life. Life is hard enough for a young black man in this society. Now you're going to make it even harder. Come on, man. Really? Go to school, study hard. You become something in this life. We'll give you a lawyer now. Don't go back to any Target. It's a part of your bond condition. If I find that you go back to Target, guess what happens? Right. I'm not asking much. Just follow the law. Don't pick up any new cases. Don't go back to Target. And then I'll provide you a lawyer today. All right? Okay, guys. I'm going to have you sign a reset with Victoria. We'll have you take your seat in the jury box. I need you to fill out an application for me, and then we'll have you talk to someone else. Okay? Yes, ma'am.